Good afternoon. My name is Stephen Ide, Senior Fellow at the Manhattan Institute and moderator for today's event, Crime and Mental Illness in New York City, Community Solutions. At present in New York City, we clearly have a big problem with the fact that far too many people with serious mental illness are far too deeply involved in the criminal justice system. Jail statistics bear this out. 16% of city jail inmates have a serious mental illness compared with only about 5% of the general adult population. Recent years have seen a steep decline in the overall city jail population, but the rate of serious mental illness on Rikers Island has remained stubbornly high. We've also seen a number of violent incidents in public places, especially the subways, that seem to have had a connection with untreated serious mental illness. Most notably, there was a January death of Michelle Go, a subway rider who was fatally pushed in front of an approaching train. The man charged with that crime was ruled mentally incompetent to stand trial. The question of what to do about mentally ill offenders can be approached from multiple directions, and it has. During the de Blasio years, the 2010s, state and local policymakers made a top priority of addressing the intersection of crime and mental illness. Most major criminal justice reform initiatives, such as, for example, bail reform, had some sort of mental health justification, at least in part. Most major mental health initiatives, such as Thrive NYC, had a criminal justice justification, at least in part. And yet, despite all those efforts, both mentally ill offenders themselves and the broader public remain poorly served by the system. Hence the current state budget process and all the attention that Albany lawmakers are currently devoted to mental health questions, Kendras Law, commitment standards, funding for inpatient care, and so on. Hope, as always, is that mental health reform could take a preventative approach to the problem of mentally ill offenders, stabilizing people before they become involved in the criminal justice system. To discuss how to do that, developments in Albany and related matters such as Kendras Law and Guardianship, we've invited two leading experts from the field. Carolyn Wolf is director of the mental health law practice for Abrams Fenster. She's the country's only attorney with a family-focused mental health care law practice. She recently served as president of the National Behavioral Intervention Team Association and was selected as this year's Lawyer of the Year for Healthcare Law. Brian Stetton is policy director for the Treatment Advocacy Center, a national advocacy organization working to eliminate barriers to treatment of severe mental illness. Previously, as an assistant New York State Attorney General, Brian was instrumental in conceiving and drafting Kendras Law and later served as special counsel to the New York State Commissioner of Criminal Justice Services and counsel to the Health Committee of the New York Assembly. Thanks so much to both of you for showing up today.
Thank you for having me.
Stephen.
Carolyn, I'd like to start with you before we get too deeply involved in what's going on in Albany right now. I want to make sure we devote a proper amount of time to guardianship, because I think it's underappreciated, particularly in the New York context. You came to my attention last year because of something you wrote about the Britney Spears controversy, in which you pointed out that, whatever may be the case with what's going on with Britney and her family, a public overreaction to guardianship/conservatorship could do real harm for the seriously mentally ill and their families. So just basically, what is guardianship? How does the process work? And why don't we hear more about it in the New York mental health policy context?
Thank you. Guardianship has gotten a bad rep, I guess, in large part because of the media, the Britney Spears case. There's a lot of misinformation out there about guardianship, conservatorship, and so on. New York is a guardianship statute. Some states are conservatorship statutes, really the same thing. And in New York, a guardian can be appointed for what I call two sides of the same coin. One is called personal needs, and personal needs allows for someone to manage somebody's healthcare decision-making, where they live, what sort of treatment they can be recommended or directed to. And what it mostly buys on that side of things for people in the mental health world is that it helps get around the HIPAA or the state confidentiality statutes. A guardian can be empowered to access medical information, work with a treatment team, help set up discharge plans if somebody's hospitalized, apply for Aot or Kendras Law, make a referral, hire case managers. So put services in place for someone who can't put those services in place without some assistance. The other side to guardianship is called property management. Manage somebody's finances, marshal assets, create a budget, protect monies from somebody who may be, let's say, in the midst of a manic episode and is, spending excessively. And so, and use those funds, to get them services and assistance that they need. The downside is that in New York, unlike some other states, a guardian cannot be given the power to involuntarily commit someone or to override a refusal of treatment. It's not the biggest problem in the world because other sections of the mental hygiene law compensate for that. But in terms of expectations, people ask all the time, if I get appointed guardian or have a guardian appointed, can I force someone into treatment? The other part of that is that there's what I call the legal answer and the practical answer. So even if somebody was empowered to force treatment or force someone to take medication, how do you do that practically? We can't wrestle people to the ground or tie them up or keep them from leaving home and so on. So that's the challenge that we have. Again, sort of the legal, even though a guardian may be empowered to do certain things, and then there's the practical. The guardian can only act within the powers that are given to them by the court, and the statute requires that those powers be what's called narrowly tailored and the least restrictive alternative. So it's only meant to have powers for those situations that the person can't manage their own. The legal standard, and guardianship is under Article 81 of our mental hygiene law, the legal standard is not danger, unlike the involuntary commitment standards, but it's a lack of capacity. It's a capacity standard. Can you act in your own best interest? Do you understand what your needs are? Can you survive safely in a community situation or in other settings? And what are called functional limitations. Are you working, going to school, managing your finances, paying your bills, and so on? For individuals who can't do that, that's the legal standard that we need to meet. Guardianship is state law, although there is a uniform guardianship statute, but states have to sign on to that. It's not automatic. And one of the biggest benefits that I have found in my own mental health law practice is the shifting of the legal burden. In other words, as petitioners, as asking the court for a guardian, the legal burden is ours to show capacity, functional limitations, ask for powers. However, once a guardian is appointed, the legal burden shifts to the individual to show the court, I don't need a guardian anymore. So it's a very powerful message to bring these proceedings. And it also gives a tremendous amount of incentive to an individual for whom a guardian has been appointed to, get things together, get into treatment, stabilize, demonstrate you can manage your funds, be productive, and you have, can manage your affairs in a responsible and an informed way, and go back and show the court that you no longer need the guardian. And in the mental health world, we have seen that is a tremendously big advantage to have people becoming stabilized and demonstrate that they can manage their affairs and no longer need a guardian.
So just to bring this into focus a little bit, we talk a lot about this problem of fragmentation in the mental health care system. We have all kinds of programs, all kinds of interventions. One reason why that is, though, is that people have various types of mental disorders, and even people with the same mental disorder may be in very different situations. Is there kind of an ideal case for guardianship? Are there certain things that need to be in place, such as family supports or something, that to make this particular intervention successful, or reasons why it may not work for everybody?
I mean, one of the big motivators is for everybody to be on the same page. It doesn't work well when you have family members fighting or disagreeing, when it's difficult to bring a case because everybody has a very different perspective. But overall, if families are on the same page, it can work extremely well. I also have my own bias. I don't like families to be guardian. like the Britney Spears case we saw, it doesn't work really well when you have a family member being the bad guy. You can't spend money on this, you have to do that, you need to live there. I am a very big proponent of a court-appointed guardian, and it's usually somebody we know, it's a colleague, someone we've worked with, understands mental illness, works better with a younger population, is compassionate, is patient. I always have the proposed guardian or nominated guardian meet with the family, talk to the family, make sure they're all comfortable, understands they can communicate with family, but I don't want families on that firing line. And in reality, they've already sort of served as a guardian, even without legal authority, and they are exhausted. And there is not, they have this feeling of not being able to do anything more for their loved one. So bringing in a third party can often be a huge advantage, even in the family dynamic issue. I want mom and dad to be mom and dad, son or daughter to be son or daughter. And the guardian is somebody who says, I have legal authority, I'm overseen by a court, you need to live here, or you can't have access to your trust fund right now. Or I'm going to make recommendations for treatment programs. So it actually, I think, works better that way.
And then just, lastly, again, why don't we hear more about, my impression is that in California, especially, the conservatorship is really at the forefront of that debate. But in New York, even at a time now where we're talking so much about mental health, I just hear so little about guardianship.
Well, I think part of it is the misinformation that's out there. If a guardian is appointed for you, you lose all your rights. You can't make any decisions for yourself. It's over. So I think there needs to be a tremendous amount more of information sharing, reality check, understanding what the purpose of the law is and how it can be used in a beneficial way. I think guardianship is, as I said when I started, has gotten a bad name. But in fact, if we can educate people, get the word out, that in fact it's a very supportive tool, that it can be very helpful to families especially, and that's the majority of people I work with, and that there are successes when we bring guardianship, and there are times where we can discontinue a guardianship because the individual goes into treatment, is motivated to be stable and to improve things. Family relationships can improve and so on. But also the other side, and keep in mind, it's costly to bring a guardianship in New York. It's adversarial. You're leaving a lot of issues up to a judge who, may or may not understand the issues. Most of them do, and are compassionate and want to work as a team. I just had a case, this week where the judge was very instrumental in bringing about a settlement and an agreement among the parties and really understood the issues. So it can be very much a team effort, but again, it can be costly. It is adversarial. If you can find other alternatives before initiating a guardianship, sometimes that's the better way to go. But I think it's a very useful tool in this area that we work, in which people are seriously mentally ill, substance use disorders, and related mental health medical issues.
Okay, Brian, let me turn to you now. Your organization is particularly closely associated with assisted outpatient treatment, and you, as I alluded to in the introduction, have a close personal connection essentially to the Kendras Law, having been involved in the original law's passage. Why don't you set the context for us a bit? What was the debate like in the late 90s, and why did people then think something like AOT, which was then a fairly new idea, was necessary to deal with what they were up against?
Sure, Stephen. So I would say that a serious public debate over where to draw the line between, on one hand, the right of a person with severe mental illness to live as they see fit, and on the other hand, the moral obligation we have to protect people from the consequences of truly disastrous choices that are driven by psychosis, as well as a community's interest in upholding public safety and protecting its quality of life. really began to take shape in New York a little bit before that, in the late 80s, early 90s, when it started to feel like the chickens had come home to roost on the entire deinstitutionalization movement that had begun in the 1960s. And I think that was really crystallized for a lot of people by a couple of high-profile cases that became tabloid and 11 o'clock news fodder. One of them was a homeless, crack-addicted man with schizophrenia by the name of Larry Hogue, sometimes called the Wild Man of West 96th Street, who anyone who was sentient at that time will remember. He spent over a decade truly terrorizing people on the Upper West Side, screaming aggressively at people and exposing himself and smashing property. And he would be repeatedly detained for that at points where he was dangerous, obviously dangerous. But time after time, the drugs would leave his system. He would no longer be dangerous in that moment. And so he'd be released repeatedly to repeat that cycle over and over. And this literally went on for years before the state mental health system was kind of shamed into holding on to this person on a long-term basis. And another case, of course, was Billy Boggs. She was a homeless woman who was sleeping on a subway grate on the east side, taking shockingly poor care of herself, kind of making a spectacle of ripping up money that had been given to her by passersby. And the Koch administration had attempted to hospitalize her on the basis of her being a danger to herself. And the New York Civil Liberties Union successfully won her release on the grounds that she was rationally choosing to live that way. And this, of course, horrified the general public, as did the Hogue case. And so I think that by the late 90s, the climate in New York had really made it possible to start what happened even before Kendra Webdale was pushed. There was a pilot program at Bellevue Hospital for what was then called outpatient civil commitment. And that pilot had not gone particularly well. It was a little bit half-baked. It was just kind of winding down just before the events that led to Kendra's Law, the evening that Kendra Webdale was pushed onto the path of an oncoming train by Andrew Goldstein. And of course, that horror understandably whipped up a whole new level of public outrage. I think we all wanted to know how anything calling itself a mental health system could leave such an obviously high-risk individual such as Andrew Goldstein alone to make his own choices about whether to participate in medical treatment. And I'm happy to say I was in the Attorney General's office at the time, and we harnessed that outrage and more that was driven by another subway pushing that happened just a couple of months later, where a man named Edgar Rivera lost his legs. We harnessed that to overcome a great deal of opposition we faced to get the bill through the legislature and to take a fresh look at this idea of outpatient civil commitment and try and draft a bill that was very much informed by what had gone wrong at Bellevue.
And so 2 decades on, what do you think we know now that wasn't at least as clear at that time?
Well, for one thing, that outpatient civil commitment can actually work. I mean, at that time, we would not have been responsible in calling AOT, assisted outpatient treatment, as we now refer to it as sort of the national term, and we really coined that in New York. But we were unable to really call it an evidence-based practice back in 1999. We had the Bellevue study, which did not show particularly good results. We also had a North Carolina study that had decidedly mixed outcomes. It seemed like people who were getting AOT for longer were actually doing quite well, but that particular variable had not been randomized. And so as a randomized controlled study, it actually was not finding an impact of the outpatient commitment. It's a very different story today, right? I mean, because we did not really have the evidence base behind it, Kendra's Law was put on a pretty short leash. There was a sunset attached to it, and there was a requirement to study it in great detail. And I can say at this point, 23 years later, on account of all the really incredible data that came out of New York and a few other places since, we now know not only that AOT is remarkably effective in reducing the likelihood of arrest and hospitalization and improving patients' engagement with treatment and adherence to medication, but there are all kinds of interesting things we have learned about what makes AOT work and about the real nonsense that was put forward in terms of negative consequences that would result from making this part of the system. You know, there was a claim made that this was going to lead people to not seek treatment, that this would drive folks underground because they would not want this scarlet letter of AOT hung around them, and that this would lead to folks feeling stigmatized or coerced. And we know from the research performed in New York that AOT does actually not in any way predict whether a person who's receiving public mental health systems is going to have a perception of stigma or coercion. Whether you feel that way tends, no great shock to me, to be dependent on whether you are treated respectfully and with dignity by the folks who represent that mental health system who you're interacting with. There's really nothing about the AOT model that should ever interfere with that. We have learned that the gains that can be sustained while someone is on AOT actually continue over time, right? If you look at folks a year after they graduate from the program, if they've been under AOT for long enough, that is 6 months or longer, you see them continuing to have those reductions in arrests and hospitalizations, even without an intensive service model such as assertive community treatment continuing to be applied to them. We have learned that the court order itself really matters. There were some differences in the way AOT had been applied downstate versus upstate, whereas upstate counties were less reliant on the court order and were signing voluntary service agreements with folks who were receiving AOT without an actual court order in place. And by comparing those folks to the patients receiving AOT downstate, who were all placed under court order, whether they were receptive to that or not, it was found that although both groups certainly did better than they had done before, that the court order made a big difference and had some real impacts on outcomes. We've learned that AOT saves the system a ton of money. And so on the basis of all this, we have gotten to the point where we can now call AOT an evidence-based practice, and that has led to, I think, a lot of the controversy around it dissipating.
So I want to ask you a similar question that I asked to Caroline about guardianship in terms like who's the ideal type for AOT. I mean, you have a lot of experience across the nation. You've met with families, and if we would like to eventually talk about getting the word out about these programs, expanding them in the sense of getting more people into them who could benefit from them, I think people need to, a caregiver, a family member need to think, oh, actually, that is something that sounds like could benefit me. What's the case we should be thinking of that could really benefit from Kendras Law?
Yeah, sure. And I appreciate the question because it's an opportunity for me to remind folks that this is not an intervention that's designed for people with severe mental illness in general. This is for a small subset of folks who are stuck in the revolving door of both the mental health and the criminal justice system, who are repeatedly hospitalized or arrested, or both, as a direct result of the difficulty they have engaging with the treatment that is prescribed for them. So that even if in a particular person's case, we're able to solve for some of the many challenges that the system faces in terms of actually getting people connected to the treatment that they need, we very often see folks who will disengage from that, who will step away from their medication and from their provider. And this is by no means, as I say, the majority of people who are dealing with these really severe illnesses. In New York City, we probably have about 300,000 people with severe mental illness, right? It's about 4% of the population. We've never had more than 1,500 people at a time under an AOT order. And I think that there's room to improve those numbers. I do think there are probably more people who meet AOT criteria than we've been able to place under AOT at any given time, but it's not wildly low, right? I mean, if we doubled it, if we got to where we had 3,000 people under AOT, we'd still be only talking about 1% of people with severe mental illness. So the nice thing about the AOT law in New York, Kendras Law, is that it really defines the population we're talking about in the statutory language. You have to meet a certain set of criteria that have to be proven by clear and convincing evidence. And at the heart of that is a finding that you have not only had repeated hospitalizations or a violent incident occur in the last few years, but that those were the direct result of a difficulty you had adhering to treatment. And, usually this difficulty that we see with people with severe mental illness and staying adherent to their treatment in a way we don't tend to see with other types of illness is a result of something called anosognosia, or lack of insight. And this is a neurological deficit that afflicts in some way or another about half of people with schizophrenia, about 40% of people with severe bipolar disorder. And it basically means a person is unaware that they have the illness. It may be something that comes and goes. For some folks, it's fixed. But when someone has anosognosia, no matter how painfully obvious it is to everyone around them that they have this illness and need for treatment, they can't see it. The idea to them is absurd. And they are instead obsessed with whatever their delusion or hallucinations are telling them they need to be concerned with at that moment, rather than getting help for an illness that they're just sure they don't have. It's not denial. People often call it that. It goes way beyond, denial is a universal human defense mechanism we all practice at one time or another. When you're in denial, you actually do know the truth deep down. That's not what's going on with somebody with anosognosia. And so I think it's fair to say that is the heart of the population we are trying to serve with this intervention. I think it's also worth noting here that we are not necessarily talking about someone who is currently facing criminal charges, right? This is a misunderstanding. Sometimes AOT is conflated with a similar concept of mental health court, where you are placing someone under a court order as a way of diverting them from the criminal justice system because they're currently facing a charge that you hope to make go away. AOT is purely civil. There's no crime that needs to be committed as the price of admission into the program. That said, most of the people who we have placed in AOT do have some significant experience with the criminal justice system.
Carolyn, these are matters you've also worked with. What's a useful way to think about the difference between guardianship and Kendras Law?
Well, they're not mutually exclusive. So there are oftentimes someone needs a guardian, but we have the guardian also, if they're not in the hospital and the hospital is not using it for a discharge plan, has the ability to make a referral to the AOT team, and every county has an AOT team that administers this law and oversees individuals who are part of the program. So again, they're two different things, but not mutually exclusive. The legal criteria for guardianship, as I said, is capacity and functional limitations. The criteria, as has been said, is for AOT is non-compliance, a history of hospitalization, and some other criteria that is part of the law. So they serve two different purposes. The AOT teams are not there to be the guardian. Their powers are not as expansive, so to speak. They're there to oversee a treatment plan that's court ordered, compliance with that plan. They have the option of bringing someone back to a hospital for an evaluation if the person decompensates. So hopefully early intervention or being proactive heads off somebody becoming more seriously ill or getting involved in the criminal justice system. So AOT serves that purpose. It's oversight and compliance. Guardianship, deals with money and ascertaining benefits and directing people into different areas of treatment. Somebody who, what I call, actually becomes like a legal parent. I say to families all the time, you're a parent, to age 18. And of course, you're still a parent after that. But after 18, your son or daughter becomes a legal adult. And now you need somebody with legal authority to direct them into treatment or financial oversight or whatever it is. But they can be used in conjunction with one another. And they're part of what I call my mental health legal toolkit. AOT, hospitalization, mental health warrants, guardianship, case management, and so on.
Yep.
So let's move into the current debate and the budget process and what people are talking about doing right now. The Albany budget process is never transparent. It's not right now. We don't exactly know every last detail of what's going on here because we never have, going back many years. But you guys follow this stuff very carefully. In some cases, you've been involved in some of these discussions, drafting potential legislation and so forth. And this is to both of you, just what are the most important changes? What should we be looking for? And what are the most important mental health changes that you think may come out of the current budget process?
You want to take that
Happy
first?
To start. I'm sure we're going to be aligned in this. Certainly the expansion of Kendras Law. There are many times I have clients who would benefit from this, meet the criteria, and for whatever reason, don't become part of that system, or they're bounced off of Kendras Law. One thing that I have an ongoing debate about in that area, just to get back to AOT for a moment, is when people do really well because of Kendras Law, they're bumped off of the system and out of the program. And then many of them decompensate. Why are they doing well? It's because of the success of the law. And as a result of doing well, the belief is you don't need it anymore. And so you get bumped off, and we're back having that same discussion again. But aside from that, I think any expansion to the Kendras Law is hugely necessary. In addition, the need for funding. I mean, that is really the key to getting any change, in my opinion, in the mental health system. Funding for housing. Housing is our biggest challenge in this area. And as you can see from, the homeless issue that just keeps expanding, housing, funding for programs. We need more mental health professionals in the system, psychiatrists, psychologists, therapists, funding for support services, funding for, people's benefits, for them to be able to be given job training, support for going back to school and earning a living. And so, to me, that is always the bottom line here. Without money to fund the right programs and have people in authority and who are leaders in the field direct that funding, because it can sometimes get lost in the system. And often they're not asking those with boots on the ground, so to speak, how best would that money be spent? But to me, that is really the biggest issue here in terms of making any changes and, getting some improvement for the lives of people, with serious mental illness and the families who love and care for them.
Yeah, to Carolyn's point, just to amplify the importance of funding and actually building a robust network of community-based services, I actually think there's probably some good news on that there doesn't seem to be a lot of debate among the parties that are working out the budget now that there's a need for huge investments in supportive housing and crisis centers and all kinds of good psych beds, very high on the list. And I think we're going to see a lot of that stuff in the budget. That's not really one of the areas where they are haggling, from what I've been able to glean. In terms of the issues that are outstanding, as happy as I am to see the governor really holding firm on the need for some changes to Kendras Law, and I think the things she's proposed make great sense and will certainly lead to the law being applied in a more streamlined fashion and give us an opportunity to bring people back into the program who have fallen away from it. I actually don't think that's quite as groundbreaking, as much of a game changer as another piece of her 10-point safety plan that I think has gotten a lot less attention. And it may be that the decision has already been made to kind of punt this issue to the rest of the legislative session after budget. But there's another thing she's proposing, and this is taken even further in a really great bill proposed by State Senator Diane Savino, where there's an attempt to define what it means to be dangerous to yourself in a way that would have been really helpful back in the Larry Hogan and Billy Boggs days and remains extremely needed today, right? Because New York is one of only 4 states that do not define what it means to be a danger to yourself or others. And that's really the crux of what it takes to get somebody committed for inpatient care, as opposed to Kendras Law, which is about civil commitment for outpatient care. And it's not so much about whether you are dangerous at this moment. It's about whether you have a history of becoming dangerous and focusing on what your history tells us is likely to happen in the future. The inpatient commitment standard is really about, is this person dangerous right now? And because New York is one of only 4 states that has not defined that term in any real explicit way in its law, there is this tendency to assume that you are only dangerous to yourself or others if you are violent or suicidal or acting out in some really dramatically dangerous way, such as walking into traffic or jumping off a building thinking you can fly. And of course, a person who cannot meet their basic survival needs, who cannot meet their need for food, clothing, shelter, is a danger to themselves in a very real sense, as is someone who cannot recognize that they are experiencing psychiatric deterioration, that their brain is actually suffering with each day that they remain in a state of untreated psychosis, such that it may be a lot harder to help that person recover if we wait to give them help. There is language floating out there that the governor has proposed that would clarify that in New York law to make inpatient commitment a lot easier and give the city of New York a lot more authority to actually go down in the subways and help lots of folks who are in desperate need of care, but can't recognize that for themselves. So that's one thing I continue to hope if it's not going to come out of the budget process, is something we can see enacted before the end of the session.
I just want to add to that, if that were to happen or some clarity come to that, and I completely agree with you,
Yeah.
is the need for education, public
For sure.
education. There's a huge amount of misinformation. Much of it leads to stigmatizing people with serious mental illness, but educating people as to the realities, because that also addresses expectations, which is a big challenge. The system can't compensate for everything, but what are the realistic expectations within the system, or hopefully a change in the system that can benefit everyone, is really, really critical.
Very much so. And not just public education, but also education of the various professions that are charged with interpreting the civil commitment standards in New York State. So that involves police who are making calls on the street. That involves psychiatrists and doctors in emergency rooms who are deciding whether or not to hang on to somebody or discharge them. It's going to require judicial education as to what exactly the standards are and what case law has said about some of this stuff, which is often just totally forgotten in the way these laws are interpreted in court. So, yeah, there are lots of things that need to happen.
Yeah, I want to return to this question, the issue of stigma in public education in just a second. But before we leave commitment standards, just to make sure I understand what we're talking about. So this is not about adding a so-called grave disability standard to New York law. It's about keeping dangerousness, but sort of giving it more clarity. So that's the first part. And second part, based upon what you know about, I know that the Treatment Advocacy Center looks at treatment commitment standards nationwide, including like places like California, whose mental health system also has a bad reputation. What do we know from that experience about what we could hope for in terms of clarifying commitment standards in the way that's being discussed?
Sure. So, I think one of the things that's been frustrating to me and a lot of people at the Treatment Advocacy Center about the debate that's raged for decades on what commitment standards ought to be is this false choice, right? This idea that we have to go beyond a person being a danger to themselves or others. Some have said that you shouldn't have to be a danger to yourselves or others to be civilly committed. And this idea of grave disability, that you cannot meet your basic survival needs, has been presented by some as an alternative to finding a person dangerous to themselves. I've never seen it that way, because to me, it is a way of being a danger to yourself. And so, yeah, there are states that break this out as two concepts. You're either dangerous or you're gravely disabled. I think a much more productive way to discuss this and think about it and argue about it is to, ask whether a person who cannot meet their survival needs is a danger to themselves. It just seems like it's all of a piece. And so we don't really have to debate on whether we need to go beyond dangerousness or whether the Supreme Court has said you can commit someone who is not dangerous. At the end of the day, we're really just talking about what it means to be dangerous to yourself or others, particularly what it means to be dangerous to yourself, because the dangerous to others part is not really that controversial. So I hope that answers the question, gives you some clarity there. In terms of, I think you were also asked about what the experience of other states that actually have these gravely disabled standards.
Yeah, I mean, New York has always had a reputation of having a very strict commitment standard,
Right.
But there are other states that also have these big mental health challenges whose standards are not as strict. So from that perspective, what could we expect?
Yeah, and I think that really speaks to the fact that fixing this part of the law is a necessary but not sufficient component to having a functional mental health system. It's also very much about beds and about having enough professional folks to staff those beds, and to have judges actually understand what the law says. And so I think there are states where the law is a whole lot better. And in particular cases, I can certainly show you anecdotal evidence of folks who got committed, got help, that would not have been able to at all in New York because the law was not on their side. But systemically, in terms of seeing real big differences in the numbers of people who get committed and whether people get committed early enough, you have to look to a lot more than just what the law says. And so the problem of not having enough beds and being short-staffed in psychiatric care is a fairly universal problem. And there are many states with decent laws that are grappling with that. And so, not surprisingly, the system triages. With the resources they have, they tend to reserve them for the people who are violent or suicidal and jumping into traffic, regardless of what the law says. And that's a frustration and a fight we're continuing to have.
Well, I
And I
also,
would never want to suggest that just by fixing the law in New York, everything's going to get better overnight either,
right.
for that very reason.
Language is really important, and people connect or disconnect from language. So it's really important, if you're going to write a law and use certain language, that it be clear, that people understand what it is. I mean, even the term gravely disabled, first of all, what does that really mean and who fits into that? It's a scary word, in my opinion. I don't know if there's an alternative to it or other language that can be used, but it's really important to use language that people will understand and to define those terms, as has been said. So what does that really mean? Inability to care for yourself. I mean, the vast majority of people who can benefit from being in a hospital setting at a particular time are not homicidal or suicidal. It really does go to an ability to care for yourself, putting yourself in a dangerous position where people might strike out at you, poor judgment, lack of insight, all of those other aspects that come into play when people, are in that situation and likely could benefit from an inpatient hospitalization at a particular time. And so I agree, not only educating the public, but educating the mental health professionals who are really the gatekeepers. Those psychiatrists in the emergency department are the first line for whether somebody's committed or not. And it's really important for them to understand what the legal guidelines are in making that determination, in addition to the clinical guideline. And, it's important for people to understand psychiatry is the only area of medicine that is so closely linked to the legal system. So, commitment, treatment, and so on, is guided by what the legal statutes say. It's not strictly a clinical decision. It's meeting certain criteria. And, it's important for people to understand that as well.
So Caroline, early on you mentioned the value of getting the word out about guardianship. We're circling around this theme of public education. I want to connect this to this the whole issue of stigma. Okay, stigma comes up all the time in mental health debates, but it strikes me that these programs, these interventions, guardianship, AOT, there's a ton of stigma about them. I mean, there's so much news coverage. It's so grudging anything positive that you want to say about them. Like, these are only for people who are just a complete mess, who couldn't be helped out in any other way. What do we do about the stigmatization of interventions programs like these? I mean, is it like, I know the Tribute Advocacy Center sometimes has forums where they have people who've been on AOT talk about it, or like, something similar to, like, is it subway campaigns? It's like when drug company ads show how happy people are when they're taking their meds. I mean, how do we convince people, get the word out? People who have families, people who have mentally ill relatives, this might be something that could benefit from you, and there's no reason to feel ashamed about that.
Yeah, and that's very tough because of the stigma. Very often families don't want to go public. They don't want to say, I have a child who's schizophrenic, or a child who suffers from bipolar disorder, or a spouse. Often they're high profile people themselves. And I have to credit many of the celebrities who have come out and been open about having some sort of mental health issue. We need more of that. Those are the people who the public listens to and gives a lot of credit to. So I think it's important for everyone to be on the same page and have the same goals of addressing the stigma, showing that, mental illness is an illness. If people have a broken leg, or they have a heart condition, or diabetes, they're open, they'll talk about it, they'll tell their neighbors. You don't see that happening with mental illness. It's sort of been categorized in a different way. But if we bring it back to the fact that it's an illness that people can recover, can receive treatment, can stabilize, I think that will go a ways in breaking down some of the stigma. And as I said earlier, there's so much misinformation out there. If you're mentally ill, you're violent. Well, in fact, the reality is people with serious mental illness are more often the victims of violence than the perpetrators. Separating out, somebody who's schizophrenic from somebody who's a sociopath who just, wants to kill people, as opposed to somebody who has, a mental illness and likely isn't going to go out and kill people. So, again, I think language and education and information and coming from people who others listen to, like celebrities, can really be very helpful in addressing the issue of stigma.
Thank you for that. To return to this issue of how the quirkiness of mental health as a field of healthcare that involves lawyers so much, I think that connects to the inevitably punitive reputation that these interventions that we've been talking about have. These terms, punitive, coercive, they come up all the time, and I would say this characterization plays a big role in the stigma attached to Kendras Law and guardianship. And to some extent, I think this may come from people who think of themselves as proponents of these interventions because they want something that's frankly a little bit stronger than what they've been hearing in terms of mental health programs trying to deal with people with anosognosia who've been involved in the criminal justice system, the hardest cases. So sometimes people overreach in saying what these stronger methods are going to achieve. How do we reconcile that? And like in particular, what I'm trying to get at is this sort of like the black robe effect of Kendras Law. So these are interventions that involve courts and lawyers, but they're actually not punitive, right?
Mm-hmm.
That's exactly right. So there's nothing about assisted outpatient treatment, the program established under Kendras Law, that is punitive. It's understandable that people assume that at first blush, right? Because there is this court order involved at the heart of it. And people tend to think normally of court orders as being effective precisely because people who are placed under them are fearful of the consequences of violating them. That is, they're fearful of being held in contempt of court, which could lead to you being thrown into a cell or having fines pile up on you each day that the contempt continues. That's totally off the table with AOT, right? The law specifically prohibits a judge from holding somebody in contempt for violating the order. Another remedy someone might imagine as to why this would be effective is that people sometimes think that a person who doesn't take their meds as directed in an AOT order is going to be physically restrained and have those meds administered to them. That is something that takes place as a last resort in a hospital setting. It does not take place under AOT at all. That requires a finding that the person lacks capacity to make treatment decisions, which is not part of the AOT criteria. So with those remedies sort of off the table, sometimes do people throw up their hands and say, well, what is the point? This seems kind of toothless. It seems like a paper tiger. Yeah. And that's where we really get into what we mean by the black robe effect, because what it really is about is getting the person's attention, right? The solemnity of a court process, having a judge say to you after going through this kind of ritual of a hearing, I've made a determination that this is something you need and this is something I'm going to be paying attention to. The idea is that it has an impact on a person beyond being told by their mom or their doctor for the umpteenth time that this is something you need to do. And that's not to say there is no legal effect at all in the court order. It wouldn't work if there wasn't, and that's a lot to do with why the Bellevue pilot was kind of a failure. There has to be a consequence, and it's not punishment. It's just that the court order, when violated, leads to a little bit easier procedure for getting the person brought back in for a short-term hold for evaluation. And that, at the end of the day, is a medical intervention. It's about helping the person. It's not about punishing them.
And the same for guardianship. Those of us who do guardianships, we talk all the time about, yes, it's a court and a judge and a court order and a legal process, but we're talking about people's lives. This is not a corporate merger. This is not a real estate deal. Those, who are in the guardianship world and in court, and the judges who hear these cases, we're all very well aware that this is about people's lives and helping them, not punishment, setting up systems to keep them safe, to help them act in their own best interest, or for us to help oversee their best interest. But, as Brian said, it's not meant to be punitive. There aren't criminal legal consequences that come from this. They are civil actions. And even the diversion courts or mental health court is meant to get people treatment. That's the carrot and the stick in the criminal justice system. You can go into these diversion courts, follow a treatment plan. We want you to get better. Or the criminal justice system kicks back in. And sometimes people do need that in order to gain some insight, understand what the consequences are, be motivated to want to stabilize and not keep coming back around into that system over and over again. So there is what I've deemed a psychological component to this. We've seen it in AOT. And just as Brian said, if a judge says, you need to do this, and here's a piece of paper in the form of a court order that the judge is signing, there are many, many people who will adhere to that just by virtue of respect for the system and the authority.
On the topic of misinformation in Kendras Law, I did want to take up the question of race, because it's every time Kendras Law is debated, it always comes up. In a recent Gotham Gazette op-ed, the noted advocate Harvey Rosenthal co-authored this piece with a state senator, Samara Brook, and referred to the glaring disparate racial impacts of Kendras Law. I know this is something you've paid a lot of attention to, Brian. I think it might be useful to respond to that.
Thank you. I appreciate the opportunity. This charge stems from a 17-year-old report put out by New York Lawyers for the Public Interest, in which they did some analysis and found that African-American residents of New York City were many times more likely to be placed under an AOT commitment than was a white resident of New York City. They said similar thing about Hispanic residents of the city, though they're not quite to as great an extent. And this was one of the questions that the independent research was tasked by the legislature in addressing. What the opponents never seem to mention is that this report was thoroughly analyzed and thoroughly discredited by the analysis of Kendras Law that was done in 2009, where they really took a serious look at it and found that the original report had left something very important out of the equation, which is that there is a disproportionate number of African Americans and Hispanic folks in the public mental health system in this revolving door. And there are lots of terrible reasons for that. It has to do with the fact that race is associated with being poor and being in the public system as opposed to being in the private system. It has to do with the fact that people of color are more likely to have their outbursts in the community due to mental illness result in an arrest. And so people wind up with multiple arrests that might not have happened as often with someone white. No one likes that. But AOT is a downstream reaction, right, to the fact that, it's drawing its population from the folks who happen to be in the public mental health system. And to pin the blame for that disproportionate representation on this corrective measure that's just taking the community of folks that we have and trying to help them and give them liberation by freeing them from this horrible cycle of winding up hospitalized and arrested again and again. It's illogical, and it really speaks to the fact that they're not seeing AOT for what it is. So, the idea that there is this disproportionate representation that when you correct for these demographic factors actually doesn't exist. But, it seems to me, if anything, someone who's really committed to racial equity should be vigilant in making sure that we don't underrepresent people of color in these programs, because this is not another pair of handcuffs you're slapping on people, right? This is handing someone the key to the handcuffs they're already wearing. And so why wouldn't we want to make that available to folks who are arrested and hospitalized way too often?
We're running short of time, but I did want to make sure you guys got the opportunity to slip in anything that you haven't seen addressed yet. And just my general question is, you all have followed these debates for a long time. What is your take on the current debate? Is there any way it seems different to you than 5-10 years ago? What strikes you about the debate as it's going on right now? Briefly.
Carolyn, you want to take that first?
Or anything else?
I think just the debate. I think there's just more conversation. I think it's an issue that's come to the forefront more than ever before. I sadly have to credit COVID, I think, in part for spurring on more of this debate. The statistics that are coming out as to the increase in suicide, increase in anxiety and depression, people thinking more about their mental health. And, I try to use that terminology because, as I said earlier, language is really important here. Rather than saying you're mentally ill, talking about people with mental health issues, because not everybody has an Access One, as it used to be called, diagnosed mental illness, but there are still people that are challenged by mental health issues. As I said, anxiety, depression. I think there's just more talk about it because of the pandemic. I'm happy to see there's more talk about it, more focus on the issue of funding. The real key to success in this area, in my opinion, is being proactive and being preventive. Same for school shootings, same for, violence, other types of violence. The whole idea is to be preventive, and the whole issue of preventive medicine, which has been popularized in the medical side of things, but maybe not as much on the mental health side. So, if you can head it off and intervene early on, certainly the mental health professionals bear out the fact that you can be much more successful in people stabilizing and leading more productive lives. And so, I think for a variety of reasons, we're just happy to see the conversation being, happening more and more, and a focus on budgets that are addressing, mental health issues and mental health needs.
Mm-hmm. Yeah, I would say that one of the things that's really changed for the better in the last 5 or 10 years is that the controversy around AOT has really subsided a great deal, at least nationally, maybe not as much in New York. But with the elevation of the research that we've been able to publicize and bring attention to, I think that it's fair to say that in our work around the country to get these programs launched, most of the resistance nowadays that we face is not as much ideological or philosophical as it was 20 years ago, more pragmatic and logistical, how local mental health systems struggling with how they make the upfront investments that it takes to make AOT work. And one of the real breakthroughs we've had in getting to that point is that SAMSO, which is the federal agency that funds and promotes innovations in mental health, at one time was very hostile toward this concept. And today I'm happy to say they are a real great partner in our work to make this a universal practice of mental health systems everywhere. We have a federal AOT grant program administered through SAMSO that since 2016 has enabled us to get 40 new AOT programs launched in jurisdictions that were not practicing it at all previously, even though they had laws on the books allowing them to. So I see many good things ahead in our quest to make this practice universal.
Well, I hope you're right. Yeah, just a couple last points to wrap things up. I mean, just my impression, regardless of what specific policy changes, legal changes we see, anytime you have a debate like this, it's just a way of taking the temperature of politicians, policymakers, where are they at on questions such as the untreated serious mental illness. I feel like I see more top policy makers, the mayor, other officials talking about things like the IMD exclusion, the need for more access to inpatient care than was the case 5 years ago. However, at the same time, if we're still relitigating whether Kendras Law is a racist law, a law that was passed in reaction to, by the way, a white man pushing a white woman to her death in front of a subway train, that's kind of a sign in my eyes that we haven't moved as far forward as I would like. But maybe this is just the way reform has to go. It's a marathon, not a sprint, and these are just the first steps to a better future. It's also possible that things could shake out that way. We have to wrap up. Thanks so much to our panelists for this extremely insightful, provocative discussion. Thanks also to our audience. Please, everyone, sign up to our website, the Manhattan Institute's website, to receive updates from our Policing and Public Safety Initiative, which includes information on various events relating to policing and public safety. Also on the Manhattan Institute's website, you can also check out our research, subscribe to our newsletters, and if you are able, please consider supporting the Manhattan Institute at the link you see below. The Manhattan Institute is a nonprofit organization, and our work depends on support from people like you all. Thanks again. This has been a great panel. Here's to hoping for a better future with respect to serious mental illness.
Thanks so much, Stephen.
Thank you.